Court will start the court this morning by calling 2018 Baxter County Criminal Case 2018-376, State of Arkansas versus Christopher Jorsch. All right, Mr. Jorsch, you're appearing before the court at this time for purposes of changing your plea on the charges against you in this matter.
Yes, sir.
And the charges against you are furnishing prohibited articles, a Class C felony. Do you
Yes,
understand that?
Yes, sir.
This change of plea is brought about by an agreement that's been worked out for you by your attorney, Mr. Cooper.
Yes, sir.
Have you discussed the terms of the agreement and the punishment you're to receive with Mr. Cooper? All right. I need you to speak up a little
Yes,
so
sir, I
the
have.
court can hear you.
Yes, sir.
Because I can tell what you're saying just by looking at you, but it's important she hear your answers. So you've gone over it, Mr. Cooper. You understand the terms of the agreement?
Yes, sir.
Are you satisfied with the advice and the representation Mr. Cooper's
I am.
provided you? On the charge of furnishing prohibited articles, a Class C felony, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to an agreement. The agreement is set out in writing in the document I'm holding up right here called a plea statement. Have you read through and signed this plea statement?
I have. Yes, sir.
So you, in going over this plea statement, have you read through it and do you feel you understand what's set out in it?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
I do.
You understand that by pleading guilty, you are giving up certain constitutional rights you have?
Yes, sir.
The primary right you give up is your right to a jury trial. With that right to a jury trial, you're also giving up the right to confront the witnesses that would appear and testify against you at trial, and the right to be represented and assisted by an attorney throughout the trial process.
Yes, sir.
You're also giving up the right to appeal. All of those are rights you're giving up. You
Yes,
understand
yes, sir.
that? And understanding what rights you're giving up, are you still willing to plead guilty?
I am.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
No, sir.
As you plead guilty here today, are you admitting that to your participation in the acts that constitute the crime?
Yes.
Are you admitting that on or about August 23rd of 2018 here in Baxter County, that you were found to have in your jail cell cigarettes and parts of cigarettes in your jail cell, a prohibited article?
Yes, sir.
Based on those statements, the court's going to find the defendant has freely and voluntarily entered his plea, done so after consulting an attorney, and has admitted to his actions that constitute the crime. On that basis, at this time, the court finds the defendant, accepts the defendant's plea of guilty, and finds the defendant guilty of furnishing prohibited articles of class into the jail and the Class C felony. Will sentence the defendant in accordance with the agreement to 5 years of supervised probation, subject to the standard terms and conditions of probation. As a special condition of probation, the court is ordering the defendant to serve 45 days in the Baxter County Jail. He will receive credit for time already served, which is indicated as 32 days. The court is imposing the court cost of $200, a fine of $2,000, the statutory DNA fine of $250, booking administration fee of $20, and a public defender's fees of $200. All of those amounts will be due and payable as a term and condition of the defendant's probation, payable in regular monthly installments of not less than $100 per month. The court is placing the payments will continue each month after the first one. The first one will be due 60 days after the defendant's release from the Department of Corrections, from the jail, payments will continue each month thereafter until paid in full. Court is reviewing and signing the written terms and conditions of probation of the defendant, and signing them and making that an order that the court that the defendant has to abide by. I'm going to direct at this time, or note that the defendant has signed the acknowledgement indicating he has read, understands, and will comply with the terms and conditions of his probation. Court is directing the defendant will meet with the probation officer here and get set up on probation. You may be excused to do so, sir.
Thank you.
All right. So the court is calling 2018-472 State of Arkansas versus Matthew Knightman. The court is also calling 2018-416 a revocation case. Mr. Knightman, you're appearing at this time for purposes of changing your plea on your charges, is that correct?
Yes.
Can you hear me all right?
Yes, sir.
All right. So you understand you're appearing at this time. It's my understanding to accept the plea agreement that's been worked out for you by your attorney, Mr. Cooper. Is that correct?
Right.
And it involves two cases, 2018-472, where you're charged with possession of drug paraphernalia, Class D felony, and 2018-416, where you're charged with violation of the terms and conditions of your probation. You
Yes, sir.
understand that?
Yes, sir.
All right. Have you discussed with Mr. Cooper the terms of this agreement and the punishment you're to receive?
Yes, sir.
And in going over the agreement with Mr. Cooper, do you feel you understand what the punishment is that you're going to receive and the terms of the agreement?
Yes, sir.
And are you satisfied with the advice and the representation you've had from Mr. Cooper?
Yes, sir.
On the charges of possession of drug paraphernalia related to methamphetamine or cocaine, a Class D felony, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to the agreement. As I said, the agreement is set out in writing in this document I'm holding up called a plea statement. Have you read through this plea statement and signed it?
Yes, sir.
In going over it, do you feel you understand what's set out in the plea statement?
Yes, sir, I do.
You then understand the nature of the charges against you in that case and the full range of penalties you're facing?
Yes, sir.
So you understand what's set out in here, and so you understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty?
Yes, sir.
When you plead guilty, you give up your right to a jury trial. Do you understand that?
Yes, sir, I do.
And with that right to a jury trial, you're also giving up the right to have an attorney represent you and assist you throughout that entire trial process. You're giving up the right to confront witnesses that would appear and testify against you at trial. And you're also giving up your right to appeal. Do you understand that?
I do, sir.
Understanding the rights that you're giving up, are you still willing to enter this plea of guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
No, sir.
As you plead guilty here today, are you admitting to your actions that constituted the crime in this case?
Yes, sir.
Are you admitting that on or about October 9th of 2018 in Cotter, Arkansas, here in Baxter County, you had in your possession an item of drug paraphernalia, a meth pipe? Is that correct?
That's right.
And are you admitting that?
Yes, sir.
Based on those statements, the court now finds that the defendant has freely and voluntarily entered his plea of guilty, done so after consulting an attorney, and he has admitted to his actions that constitute the basis of the crime. On that basis, the court accepts his plea of guilty. However, pursuant to the terms of Act 346 and the agreement in this case, the court is at this time going to withhold formal adjudication of guilt of the defendant on the charge of possession of drug paraphernalia, Class D felony, and place the defendant in accordance with the agreement on 5 years of supervised probation, subject to the standard terms and conditions of probation. The court is imposing court costs of $200, a fine of $2,000, the statutory DNA fine of $250, the Bowie administration fee of $20, public defender's fees of $200, and drug crime assessment of $125. All of those amounts will be due and payable as a term and condition of the defendant's probation, payable in regular monthly installments of not less than $100 per month, beginning within 30 days of this date and continuing each month thereafter until the full amount is paid. The court has reviewed and signed the written terms and condition of the defendant's probation, and at this time notes that the defendant himself has signed those written terms and conditions of probation. The court's going to direct, he signed the acknowledgement and he's acknowledging that he has read, understands, and will comply with the terms and conditions of his probation. The court is going to direct that Mr. Notman will meet with the probation officer to get reset up on probation. As a part of this agreement, the previous probation he was is on will continue, but the revocation process in 2018-416 is dismissed. So you're going to now be on probation in both of these cases. Do you understand that?
Yes, sir.
And you're going to have to comply with the terms and conditions. What I'm going to tell you right now is it's extremely important that you read those written terms and conditions of probation, because you're going to be held accountable for complying with them.
Right.
The reason that's important, because you're being given an opportunity that not really very many defendants get, which is to leave the courtroom without having a formal conviction entered against you in this case. And so you need to take advantage of that. Any violation of the terms and conditions of probation can result in you being brought back into the court and formally adjudicated guilty, and that'll add a felony conviction to your record.
Right.
You may be excused at this time to meet with probation. The court will call 2018-386 State of Arkansas versus Colton Trey King. Mr. King, the court has before it a plea statement indicating that you're prepared to change your plea in this matter. Is that correct?
Change it? I haven't made any pleas at all.
Well, you appeared before, I believe, and entered a plea of not guilty at arraignment.
Yes.
And so when I say change the plea,
All right.
my understanding is you're now prepared to change that plea from not guilty, so that's why I say change the plea. And this is
All right.
pursuant to an agreement that Mr. Cooper's worked out for you, is that correct?
Yes, sir.
Have you discussed the terms of the agreement and the punishment you're to receive with Mr. Cooper?
Yes, sir.
And do you feel you understand what the agreement is?
Yes, sir.
Are you satisfied with the advice and the representation you've had from the Public Defender's Office and Mr. Cooper in
Yes, sir.
particular? Now, on the charge of theft by receiving, that's a Class D felony, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to the agreement we've been discussing. That agreement is in writing in this document I'm holding up, called a plea statement. Have you read through and signed this plea statement?
Yes, sir.
And in going over this plea statement, do you feel you understand what's set out in the plea statement?
Yes, sir.
Do you then understand the nature of the charge against you and the full range of penalty you're facing?
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty?
Yes, sir.
When you plead guilty, you give up your right to a jury trial. You understand that?
Yes, yes, sir.
With that right to a jury trial, you're also giving up the right to have an attorney represent you and assist you throughout the trial process, and you're giving up the right to confront witnesses that would appear and testify against you at trial.
Yes, sir.
Finally, you're giving up the right to appeal also.
Yes, sir.
Understand these rights you're giving up?
Yes, sir.
And understanding what rights you're giving up, are you still willing to plead guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this?
No, sir.
As you plead guilty, are you admitting to your participation in the crime involved?
I'm the only one who participated in the crime at all, sir.
Pardon?
I'm the only one who participated in the crime at all.
All right. So you're admitting that back on August 29th of 2018 here in Baxter County, you were pulled over operating a motor vehicle. I guess it's a Ford pickup truck. Is that correct?
Yes, sir.
That turns out, so you were operating and in possession of it, and it turns out it had been stolen, I think originally in Tennessee,
Yes, sir.
and based on and so you're admitting that you have that in your possession. Is
Yes,
that
sir.
correct? Based on those statements, the court's going to find the defendant has freely and voluntarily entered his plea of guilty, done so after consulting his attorney, and has admitted to his actions that constitute the basis of the crime. On that basis, the court at this time accepts the defendant's plea of guilty and adjudges the defendant guilty of theft by receiving a Class D felony. In accordance with the agreement in this case, the court is sentencing the defendant to 3 years in the Arkansas Department of Corrections. The court is also imposing court costs of $200, a fine of $2,000, statutory DNA fine of $250, book administration fee of $20, public defender's fees of $200, and an amount of restitution as yet to be determined. The court will provide that the defendant is to pay those amounts that I've set out and any restitution that is agreed upon in this matter in regular monthly installments of not less than $100 per month, beginning within 60 days of his release from incarceration and continuing until each month until he has paid the whole amount. That will be the order of the court. The defendant is remanded into the custody of the Baxter County Sheriff's Office to await transportation to the Arkansas Department of Corrections. Defendant may be excused at this time. 2018-424, State of Arkansas versus Samantha Laverty. This is a case where we've got it set by the matter set by scheduling order for today for a status of the case with those same trial dates that I've in the last several cases. March 7th is the next appearance in court. May 16th is a plea deadline. May 20th is a trial week. Anything else to be done in this case?
And I'd like to address the issue of bond, please.
All right.
Ms. Laverty's bond is currently set at $25,000. She has been in our jail as of today 2 months and 10 days. She has a residence, 360 Century Park Terrace, a mountain home that she can go and live. Your Honor, as I normally state in cases like this, we know what the allegations are. They are allegations. That's all they are allegations at this point. I do not believe that Ms. Laverty has any previous felonies or any history of anything related to what her current allegations are. Your Honor, I think that a bond of $10,000 to $15,000 would be more than enough to secure her future appearances in court.
Well, I'll hear from the state.
You know, the state's position in this matter is we want to protect the victim, of course. If a bond is allowed to be less than what has been currently set by the court, which is $25,000, part of the state's position would be that she could have no contact with the victim in this matter. We just don't think it's appropriate based on the allegations and the nature of the injuries that were occurred in this situation. So if there is a bond, that's got to be part of it as far as the state is concerned, Your Honor.
What is this, where is the child at this point? It's an 18-month-old child, if I read the information correctly.
That's correct, Your Honor. It's my understanding is it's under the control of DHS at this time, Your Honor.
Boy or girl, I hate calling it a child it.
I believe it is a girl, Your Honor, if you give me 2 seconds.
And our defense had anticipated that if a bond is reduced, that the state would request a no contact. And my goal is to get a bond that will get Ms. Laverty out of our jail. And if there's a condition of no contact, then she certainly accepts that condition, Your Honor.
And where would she be living?
The address is in Mountain Home.
Okay. Is that a home that she lives in?
Your Honor, that is a home that is occupied by an individual by the name of Cody Smith, who,
Is he in any way a co-defendant with the?
no, Your Honor, I asked those questions.
And it is a little girl, Your Honor.
Little girl, very good. Court would approve a reduction of bond to $15,000. Bond is not supposed to be punishment or penal in nature, as long as the court is satisfied that that bond will be reduced to $15,000 to keep her in court. There will be a condition on the bond that she's to have no contact, direct or indirect, with the child victim or any person who is responsible, in whose custody the child is presently or who ends up being given custody of the child as a result of any action in court. Any effort on her part to contact, have information about the child must go through her attorney and the whatever agency of the state is supervising the custody of the child while this action is pending. That'll be the order of the court.
Thank you, Your Honor.
You may be excused.